Good morning. A warm welcome to this webinar hosted by the Agriculture, Aquaculture and Fishing Sector Group of Cliff Decker Hofmeyr. My name is Andre de Lange. I'm a director in our Corporate and Commercial Department and I head up this sector group. Our speakers today will be Andries Legrandsie and Alan Honey. Andries is a director in our Competition Law Department in Sandton, and Andries will be dealing with the Competition Commission's draft exemption regulations applicable to joint purchasing and buyer groups. Alan Honey is a director in our Corporate and Commercial Department in Cape Town and specializes in BEE regulations. Alan will be dealing with the BEE regulatory framework in the agriculture and fishing sectors. Please feel free to ask questions as we go along by typing your questions into the chat box functions of this webinar. The speakers will then deal with your questions at the end of the webinar. The slides of this webinar will be emailed to you later today, and you will then get the slides together with the brochure of our sector group later today. So without a further ado, I'd hand you over to Andries.
Morning, everyone. Just checking that you can hear me and see the slides. It's good to see all of you, and it's good to see a few familiar faces. It's a pity we can't speak on this webinar, but you're welcome to post your chats, and you're more than welcome to make contact with us afterwards. So it's a pleasure to speak to you today. And the topic of my section, at least, is, as Andre mentioned, dealing with the exemption, draft exemption regulations published by the Competition Commission, and we've tried to make them applicable to the agricultural sector, in the sense that the purpose of this discussion is to talk a little bit about joint procurement, buyer groups, which we know are quite prevalent in the agricultural sector, and which I think many of you might have an interest in. It's important to understand that the draft regulations, or the block exemption, is still in draft form, and we will today point out a few areas of possible concern with these regulations, areas where they could perhaps be improved. But importantly, I think the purpose of the regulations is to assist small businesses, small and medium-sized businesses, in dealing with the effects, the negative effects of COVID in particular. And therefore, some of these practices which have been identified in these block exemptions are exempted, perhaps for the purpose of giving greater clarity to the market, but also for the purpose, I think, of promoting the smaller businesses in the economy, trying to get them on their feet, and then assisting with their development. So without further ado, let's get into the details of the block exemptions. There are a whole category of agreements that have been mentioned in these block exemptions. And as I mentioned up front, we're only going to be focusing on joint procurement and buyer groups, but there are a whole lot of other agreements, some of them quite complex to interpret and to understand exactly what is meant by these agreements. So just by way of example, research and development agreements are mentioned, production agreements such as toll manufacturing agreements. Then you find the joint purchasing agreements, which may include a subset of firms in the market or similar arrangements. I think this is interesting. So we'll get into the detail of these regulations, but the regulations at one point mentioned that a requirement of the regulations, or the requirement for exemption, is that a majority of SMMEs must participate. But the definition of a joint purchasing agreement refers to a subset of firms. So that's something interesting to note. Then you find joint selling agreements where the prices of goods or services may be set through intermediaries, or the goods may be sold through intermediaries. You find what they call commercialization agreements, which include cooperation between firms relating to the selling, distribution and promotion of the goods and services, standardization agreements, and then finally collective negotiations with large buyers or suppliers. And the latter item, I think, also relates to the discussion topic for today, where buyers may engage in collective negotiations for the purchase of goods or services. And that in particular is the focus. Just bringing this discussion or making it pertinent to the agricultural sector, the category of firms within the agricultural sector that have been or would be exempted once these regulations take effect are small, medium and micro businesses in terms of this table. You'll see that the thresholds are set out there. I think one of the interesting things for discussion is whether the parties in the agricultural sector who currently participate in buyer groups or in joint procurement do fall within these categories or not. And if they don't, what they need to do to make sure that they are compliant with the Competition Act. And I think that's an aspect that requires some further debate and discussion, perhaps outside of this session. Just to give those of you that are unfamiliar with the topic a little bit of an insight into what joint procurement and buyer groups involve. Essentially, the arrangements that form part of this subset of agreements involve purchasers of goods or services who then negotiate jointly or cooperate in relation to the purchase of the goods and services. And the ultimate intent is that they would be able to negotiate beneficial discounted rates. That often happens in the context of the agricultural sector, where you have large suppliers of goods or services, seeds, fertilizer, petrol, and many of them apply, for example, volume discounts that are standardized and that are available to customers who purchase larger volumes. And if buyer groups were to coordinate their purchasing, they could perhaps qualify for these discounts, which otherwise they would not qualify for. So that's the context in which these buyer groups are formed and in which they would seek to benefit from their combined purchasing power. Now, if you take a step back and look at the theory, the economic theory behind the concerns that may be expressed regarding buyer groups, there are two essential concerns. And the one is that if you have joint purchasing agreements between firms that are operating in the market and they would be procuring their suppliers, particularly large inputs together, then the fact is that they have visibility regarding each other's input costs, and that may facilitate downstream collusion, because then they would know what the prices are at which they procure goods or services, particularly important inputs, and that would then potentially allow them to go and standardize or increase their downstream prices if they know, for instance, that the competitor has a higher input cost than they have. So that's the one theory of harm. The second theory of harm is that if you have a significant number and a large percentage as far as market share is concerned of purchasers who combine their purchasing power, then they could essentially exploit their purchasing power and they could force prices down or restrict demand in a way that is similar to a monopoly operating in the selling side of the market. So this is known as monopsony power, and that's the second theory of harm. Now, I think as far as the theories of harm are concerned, it's probably unlikely if small firms were to participate in buyer groups for these theories of harm to manifest. But still, you have this provision in the Competition Act, Section 41B in particular, which prevents and prohibits firms from fixing a purchase or a selling price, importantly, a purchase price or other trading conditions. So if you have firms, despite their size, who then cooperate with each other and cooperate to purchase goods and services together, they potentially would be fixing a purchase price and potentially would be at risk of contravening this section of the Competition Act. I don't think there are any examples where buyer groups have been prosecuted, and I think the competition authorities are well aware of buyer groups that operate in various sectors of the economy. But one of the issues I think that is raised by this draft exemption and is raised by the Commission's interpretation of this section is to what extent there are risks for smaller firms or other firms who don't qualify for being guilty of contravening this particular section of the Competition Act. And it's quite clear if you look at some of the case law, the consent orders that have been concluded over the years, that in this particular case involving Columbus Steel, there have been consent orders where parties, in this case in the scrap metal industry, have entered into consent orders, admitted to engaging in price fixing in relation to the purchase of scrap metal in this case, and have admitted to liability. Now, in this industry, I think the facts were clearly such that the potential of anti-competitive harm existed, where a large portion of the scrap metal dealers participated in this arrangement. But as I said earlier, when you're dealing with smaller firms and even perhaps some larger firms who don't fall within this exemption, the question arises whether joint procurement as such would be constitute a contravention of the Competition Act. And that is where I think, in the light of the present developments in our competition law, this question of characterization comes into focus. And there have been quite a few recent cases that many of you would be aware of where characterization is dealt with and explained. Not in the context of joint procurement necessarily, but in the context of joint bids between companies who are competitors or seen to be potential competitors, or in relation to arrangements where parties stand in both horizontal and vertical relationships, and their interactions are seen by the authorities as being anti-competitive. And in many of these cases, and I think cases like the Tourvest case, the Aranda Mills case recently demonstrate this principle. In many of these cases, the Commission has adopted a very hard line in relation to the conduct and said that characterization is not permitted in terms of the Competition Act. But the courts and the tribunal have essentially said that it is important that we interpret the Competition Act with reference to the object and purpose of this Act. And when you have interactions between parties who may even stand in a horizontal relationship, which on the face of it seems to contravene the Act, you still have to consider whether, if you look at the actual arrangement, whether it essentially contravenes the purpose and the relevant section of the Competition Act in a way that can be said to constitute a collusive arrangement. And therefore, I think that there is room currently in terms of our jurisprudence to argue that many joint purchasing arrangements, buyer groups would fall within this characterization principle, because they often involve firms that are small firms that are not in a position where they combine their purchasing power in such a way that it will result in serious anti-competitive effects. And if you look at international jurisprudence, particularly the EU, it has useful guidelines dealing with horizontal cooperation. And in those guidelines, for example, the authorities there state that it's highly unlikely that if you have purchasers who represent 15% or less of the market, that their joint purchasing would result in anti-competitive outcomes. And there may be various other considerations that authorities internationally look at. The types of things that the EU looks at is whether the purchasers or who participate in such arrangements enjoy the ability to purchase otherwise than through the buyer group. So they have to have the flexibility to participate or not participate. There are also questions about restrictive ancillary restraints that might apply. For example, if they're all forced to purchase at a particular price without any flexibility, that might be seen to be anti-competitive. And I think in our jurisdiction, I think it would be useful if one could develop alongside these draft exemption regulations a set of guidelines that deal with joint purchasing or buyer groups, so that firms who are not who do not fall within this exemption can take comfort from the fact that they are still protected and compliant with the Competition Act. And I think that's the difficulty with these regulations. There is an element of uncertainty as to whether the Commission now views joint purchasing or buyer groups involving parties who don't fall within this exemption to be in contravention of the Competition Act. And the reason for saying that is because the exemption itself says that some of these arrangements would enable collaboration between SMMEs that would otherwise contravene the Act. And I think it would be useful if in the final version of the regulations a recognition could be given to this principle that in fact certain joint purchasing arrangements or buyer groups may in fact not be in contravention of the Competition Act. So I think these are the issues that flow from these regulations that may raise certain concerns for parties who don't technically fall within the thresholds of SMMEs and therefore don't qualify for the block exemption. Just to wrap up and to raise a few points for discussion, I think it's clear that these regulations have benefits. I think it would be useful for SMMEs to be able to participate in buyer groups once these regulations come into effect. It's obviously difficult, one would think, for SMMEs in the market or for a majority of the SMMEs in a particular market to come together and to work together. And it's also not clear to what extent, if you don't involve a majority of the SMMEs, and the regulations also refer to historically disadvantaged persons in this context. If you don't actually have a majority of the SMMEs participating in a particular buyer group, whether they would still enjoy an exemption. And I think that's a particular problem and something that can be addressed in the following drafts, because it's highly unlikely that one would even know who the SMMEs in a particular industry are. And for any group of SMMEs to claim then that they've involved the majority of the SMMEs in the market to qualify for the block exemption would be very difficult. And therefore, I think one has to engage with the Commission. I think that the intention perhaps behind this section was rather that the buyer group would not be exclusionary, so that it would have an open door, as it were, to SMMEs who wish to join to actually come on board. And maybe that would be a better way of actually addressing this particular aspect, is not to require a majority of the SMMEs to participate, but rather that the buyer group would be inclusive and not prevent firms from acting or from participating and enjoying the benefits of these block exemptions. As I mentioned earlier, the fact that the exemptions suggest that arrangements such as these would contravene the Act if not exempted also raises concerns for many firms, I would think, who are participating in these buyer groups. There may be farmers, commercial farmers, for example, who have large turnovers, who technically don't qualify for these block exemptions, and they may be other firms who technically don't qualify, and they potentially feel or may feel at risk of contravening these regulations. So I think these are important things for the purposes of competition regulation. I think we all understand that SMMEs have suffered hardship during COVID. Currently, with the electricity issues that we face, are also suffering severely, and that measures such as these, which promote their participation in the market, are useful. It's also perhaps an issue that many SMMEs won't have the capabilities of actually engaging in buyer groups, won't have the knowledge to participate, and therefore it might be worthwhile for firms, larger cooperatives or ex-cooperatives, agricultural firms, to actually facilitate such arrangements in the market. And I think in the context of the regulation of mergers, we see that the competition authorities do focus on the promotion of smaller firms, SMMEs, historically disadvantaged firms in the market, and there have been many recent mergers where the competition authorities have imposed conditions and the parties have agreed to, for example, finance smaller farmers, historically disadvantaged farmers, and as such try and uplift them. And one of the ways in which agricultural firms may also assist these farmers is to assist them to participate in these buyer groups where they qualify. That might help them also to get a foot in the door, as it were, and to be able to establish their businesses in a way that is compliant with the Competition Act and will facilitate their growth. Finally, I think that the issues that are raised by these regulations do bring into focus more complex issues for firms who don't fall within the exemptions. Larger firms who participate in buyer groups may well want to take advice regarding their position. There are other ways to be compliant with the Competition Act if you are in or wish to participate in joint procurement arrangements. In certain cases, it might well be possible for the parties to merge and to enjoy the benefits, scale benefits that they would then have in the purchasing sphere. That merger, if they merge their businesses, they would be part of a single economic entity, and as such, they'd enjoy exemption under Section 4, subsection 5 of the Competition Act, where firms in a single economic entity can't contravene or won't contravene the Competition Act. And there are also other ways in which wholesalers can be formed. Perhaps smaller firms already participate in purchasing from wholesalers who have legitimate businesses through which they can negotiate discounts and pass those discounts on to smaller firms. So these are all alternative ways in which smaller firms can participate in other arrangements that are compliant with the Competition Act and that address the weak position, bargaining position that they might find themselves in. As I mentioned before, one of the sorry, I think those are the end of the slides, but one of the things that is very important in today's landscape from a Competition Act perspective in the merger context is the promotion of public interest factors. The merging parties in the agricultural sector could well consider trying to foster these types of initiatives to the benefit of smaller firms. I think that will be viewed favorably by the authorities. There are other ways, of course, of promoting public interest benefits and transactions, and one of them is through the promotion of BE schemes in the Act, and then Alan will deal with those things. So I think Alan Honey, who is an expert in the BE sphere, is someone who can talk to that and can perhaps address some of the questions that you might have as to how the promotion of BEE within your businesses might facilitate merger approvals. Just before I hand over, I think we reached the end now, and I can now just focus on some of the comments coming through. I see Rian has raised the question regarding the concept of agricultural cooperatives, which are often established, I think, to do exactly this, to benefit from the economies of scale. And the farmers or the smaller firms who participate in cooperatives often have in mind the intention to benefit from the scale advantages of these organizations. And thus a cooperative could purchase goods at a lower rate than the individual farmers, and then it would on-sell them to the farmers at beneficial rates. And I don't think the agricultural cooperative in itself, which is a separate legal entity, it's legitimately formed, it has a place in the economy, would be at risk of being seen to be a buyer group necessarily. But perhaps there are agricultural cooperatives like this whose only function is to act as a buyer group. And questions may then arise whether this cooperative is such that it can be characterized as an arrangement that is not in contravention of the joint purchasing regulations. And I think there are some complex arguments in relation to entities which are formed to serve as buyer groups and therefore might feel that they might be at risk and they might need to take advice regarding that. So I think, thanks, Rian, I think a useful comment. And then I just want to check if there's anything else. Doesn't seem to be anything else from the group, but if you have any questions, please please feel free to raise them now on the chat, or you're more than welcome to contact me afterwards. As I said, Alan will deal with the BEE regulations, and particularly in relation to the agricultural sector, and that's very, very pertinent for firms wanting to merge in this sector. And the important thing is that one has to develop creative ways to foster the public interest aspects of the Competition Act. Some of the things we've seen recently are firms who've agreed to essentially finance smaller farmers who don't have the wherewithal to run their businesses or obtain financing. And in that way, they would be able to participate in the economy, would ultimately become members of large agricultural firms or the companies that operate in the agricultural sphere. And once again, the buyer group idea might be something that firms who are looking to promote these public interest considerations within their businesses can turn to as an option to propose remedies to the competition authorities which might facilitate the approval of their transactions. So thanks very much. I'm going to be signing off, and happy to take any questions later on. Thank you.
Alan, you're on mute.
Hello, everybody. Sorry about that. Are the slides up and running? Can you see them? Okay. So I'm going to talk about the BEE regulatory environment generally first, and then I'm going to talk about specifics in the agri sector and codes applicable to it. So we'll start off by talking about the BEE Act, which is the starting point of BEE regulation in the country. It's not a very long piece of legislation. It's a constitutionally mandated piece of legislation, so it's quite important as a framework document to start off there. It contains some of the key definitions and also some of the more sort of rigorous aspects of BEE enforcement. I think it's just maybe to start off, in case nobody knows this, I suppose everybody in the country should know this. When we talk about Black people in the context of the BEE codes, and generally we're referring to everybody who's essentially not white, provided they're South African citizens. So that would include coloureds, Indians, and African people. The other key definitions you'll find in the BEE Act are things that have become quite popular, like concepts of fronting, which I'm seeing more and more being leveled quite loosely, quite frankly, in the market out there. But it's actually quite a complex thing. We're not going to talk about fronting much, but be alive to it. Essentially, fronting is where you try and undermine the act. And as the name implies, again, a good example of fronting would be something called window dressing. And that's when you put someone in a position which they're not really equipped for, actually cannot really perform. And the purpose of doing that is to achieve some kind of BEE benefit for that. The next thing I want to talk about is the actual practice and the implications of how do you get measured and what happens. And that's all governed under something called BEE codes. There's quite a lot of them, and we're going to focus on, obviously in this context, specific sector ones. But the most important set of codes is the generic codes, which were the first codes, and they've been revised and republished and amended over the years. There's a lot of them, and there's a lot of detail to it. We'll talk a bit about the generic codes a little bit in the next few slides, and then we'll also talk specifically then about sector codes and then obviously agri sector code. So I think the first important point about BEE compliance is the role of the state. The state is actually obliged in terms of the BEE Act to give effect to BEE. How it does that is that it is obliged when issuing any kind of licensing activities for any form of economic activity or concessions, etc. It must apply the BEE codes in that process. There's a bit of overlap there with procurement in the context of state entities, but that's something we can certainly have a nice discussion about in another day. The codes generally distinguish between groups of entities or entities based on their turnover thresholds So Andre spoke about SMME environment and the thresholds applicable there. In the codes, the thresholds are a bit more simplistic and a little bit more generous, I would suggest. So what you see is you've got something called EMEs, which is exempt micro enterprises. And then that's entities with a turnover of up to 10 million rand generally in most codes. There are codes where it's either higher or lower. Then you have something called QSEs, which are qualified small enterprises, and these are entities that's typically between 10 million and 50 million in turnover. And then you have finally large enterprises, which are enterprises which are more than 50 million rand. The reason for distinguishing, or one of the reasons for distinguishing between these entities, is because the compliance burden generally escalates depending on where you are. So if you're a smaller entity like an EME, you actually have an exemption, and your compliance burden is a lot lower. Similarly for QSEs, not as low as EMEs, but generally a lower compliance burden than large enterprises, which have essentially the most onerous implications. And I suppose, as Andries was saying, there is a move ahead, and you can see it throughout the regulatory landscape to try and promote small business and trying to give them a bit of a leg up and an opportunity to compete a bit more fairly in the market. And you find the BE codes that theme is quite strong throughout the BE framework. Now then we go just to measurable entities and who's measured. So maybe the other point on BEE is it's not compulsory for anybody to undertake BEE or to be measured under the Act, but it's become quite commonplace, and because government licensing, etc., filters through the economy, you'll find that then invariably there's a big take up of BEE. Now, measurable entities are obviously all private sector entities, but it also includes state entities. So some people don't know that. For example, if you buy goods and services from a state-owned entity, you actually can get a BEE score, or at least obtain a BEE benefit to some extent from those entities. So it does apply to them, and that also required to be measured. Certainly state-owned entities, not so much the state. The state is not, where the state owns any interest in an entity, that interest is neither black nor white nor anything. It's not counted for ownership purposes. That's another important point. Okay, then the most important part of BEE are your measurable elements. Those are your 5, well, there are sometimes a bit more depending on the sector code, but there are 5 elements. Those are ownership, management control, skills development, enterprise and supplier development, and socioeconomic development. We'll discuss those all in a little bit more detail as we go on. So let's talk about sector codes and the generic codes. Now, the generic codes are the first sort of set of codes, probably the most important set of codes. They govern BEE regulatory compliance on a generic basis. In other words, they don't apply to any specific sector of the economy, whereas sector codes are intended to be just that. They are normally the product of stakeholder engagement and agreement. They then are published formally as sector as well as BEE codes under the Act. In terms of the BEE Act, where there's a sector code in place, you must apply the sector code. You cannot apply the generic code. Sector codes follow to some extent the generic codes, and often are quite similar. And you'll see in agri sector there are lots of similarities, and that's to some extent mandated. There are prescriptive ways and measurement rules and tools in the generic codes which must be applied by sector codes. But you'll find lots of subtle differences, obviously, because those codes are developed by the stakeholders concerned and intended to apply to the benefit of stakeholders in that sector. So I want to talk a little bit about overlap and conflict between all of these sector codes, and how do you look at compliance. So the first potential overlap occurs in the context of sector codes versus sector codes. So there's quite a lot of sector codes out there. So, I mean, if I think of like a forest sector code, agri sector code, property sector code, and then I ask myself, how do you know when you have a business that sort of owns a forest and also land, but also does property development? It gets a bit tricky to determine, which sector code, applies to you. As a rule, those sector codes all have scoping. They specifically have to determine the scope, and what you find is some sectors, because of this overlapping in various things. For example, logistics tends to overlap throughout the economy, manufacturing also to some extent. You do find that there can be potential overlaps. The rule of thumb, though, is that you look at where most of your business is generated, and if that falls squarely within a sector code, then typically it's that sector code. As I said before, sector codes are now mandated. You have to apply a sector code where it's applicable. You can't apply the generic codes, which is what people used to do in the past. Then in terms of generic codes versus sector codes, I think the other thing you must bear in mind is that generic codes do have often a residual application, even in the context of sector codes. And that's because some sector codes, well, a lot of sector codes don't always go into a lot of detail about how one measures or attributes certain scoring. Whereas the generic codes are quite detailed and sets out lots of rules and requirements, which then guide not only the interpretation, but also the measurement principles under the codes. So you will always probably have reference to generic codes when interpreting a sector code, and often sector codes will specifically state that, where it's silent on a particular aspect, one must apply the generic codes. Group companies also gets a bit tricky sometimes to determine, in a group of companies, which of the entities have to apply sector codes, and what if there's no specific general theme? What if you have a group company that's quite diverse, that does lots of different things? I think the first rule is you look at the holding company level. If the holding company, if more than 50% of its turnover is directed at a particular sector, then it must apply that sector. But where there isn't really a specific sector that a group focuses on, then you would probably look at it at each subsidiary level, if there are subsidiaries, even at divisional levels, and apply the sector codes. Alternatively, apply the generic codes where it's not really clear that any sector code applies. Importantly, though, when you have a subsidiary in a group context and there is a sector code applicable, it doesn't matter what the other companies in the group or what particular sector code, or whether it's generic code that applies. You have to apply that particular sector code to that subsidiary. Okay, I'm going to talk now specifically about agri and fishing. The agri sector code, as I mentioned, has got a sector code. I also said to you that it's a product of engagement with stakeholders. This is the second iteration of the agri sector code. It was amended when the generic codes were amended to take into account some of the key changes that were brought in the 2015-2017 years. So what's important about the agri sector code is that it governs all stakeholders in the agri sector. So that will be all participants and players involving agri-related services and production of agri products. We'll talk about the scope and how it applies specifically in a minute. Where we've seen it, it's already being applied quite extensively, and you see it a lot in the export and import regime. So government now applies the agri sector code in its determination, for example, for granting export and import licenses under WTO trade agreements, EU trade agreements, etc. There's been quite a lot of government notices where they actually looking at providing rights and access to those particular kinds of licensing, and they specifically then apply the agri sector code in that context. The fishing sector has not got any code. The generic codes are, as a rule, applied in the fishing sector, but the fishing sector as a whole doesn't have any sector code applicable to it. Those of you in the fishing sector will know that I think it was in 2021 when the fishing rights allocation process was done. What they do and what they generally do in the fishing sector when allocating rights is they have their own criteria focused on what's important for that particular industry. In the last iteration, it was in the context of infrastructure, productive capacity, and importantly, job creation. So there's quite a strong focus on evidencing that. And then what you do is you use your BBEE scoring, but your generic BBEE scoring code to actually as part of the measurement. It's not really weighted so that you can't really see exactly where the BBEE scoring comes into it, but they don't have, and I don't know if they're actually going to ever really look at the sector code applicable for the fishing sector as is done in the agri sector code. Okay, I'm going to talk a little bit about the objectives of the agri sector objectives. I haven't listed all of them. I'll just put them all up here. Quite a lot of them, and it's quite interesting. But the objectives are important because just like you would look at a scope of any piece of legislation, or to determine its ambit, objectives are like your purposes. They also define your scope and also aid in interpretation. So there's quite a few here that we're talking about. The important ones that I've mentioned are the deracializing of land ownership. Also talks about changing management and control systems. You want to transform the agri support systems. You want to unlock the potential of Black people and entrepreneurship in the industry. And then it's got other interesting things like equitable access and opportunity to Black people and communities, social upliftment, community participation, and then specifically focus on farm workers, rights of rural and other vulnerable farm dwellers, because I think specifically in the agri sector, there's I think an acknowledgement that those conditions can be improved. And I think using the agri sector code as a mechanism to try and facilitate that is probably not a bad idea, because I suppose to the extent that agri industry is already doing that, there's now potential benefit to you because you can actually claim BE points on it. We'll talk a little bit about the detail. Okay. Now scope. So it's quite a wide scope, and we're not quite sure where it stops and starts. As I said to you, there are sometimes overlaps with sector codes, and it sometimes gets a little difficult to sort of draw the line. But in this case, you start off obviously with primary production, so you're talking about farming operations primarily, and other kinds of primary production would obviously be covered. And then it also talks about suppliers to these primary producers, that's inputs and services to them. So that covers essentially the entire supply chain to primary production. It then also talks about beneficiation and people that beneficiate products, and it includes semi-beneficiation as well. And then the last one, it talks about logistical and trading. So that's your delivery, your logistics, and your trading entities, but it's only for non-beneficiated. I don't know why they use that word. They could have maybe called it primary, but I suppose they just wanted to make it a bit clear. Well, maybe not so clear. So that one is quite wide. If you think about a transport company, and by the way, there are transport sector codes as well, although those haven't been aligned yet, so they're difficult to apply. But what you would find is logistics companies, for example, that transport grain. If it's only grain they produce, then they would fall under this particular grain that they transport. Then I suppose they'd fall under the agri sector code. If, of course, they're doing a wide range of transport activities and not just grain, then they'd probably say, well, they'd want to fall under the transport sector code. The other thing I'll mention it a little bit later again, but it's quite important to note, is that the ministry and the sector charter council has got the power to actually say that a particular company must fall within a sector code because there's some strategic significance. I'll mention it again later, but that I haven't seen that actually done, but it is possible that you may not automatically fit in a sector, or you may be, potentially fall into a number of sectors, and you can actually be directed as to which sector you can fit in. Just maybe with multinationals, just to sort of sketch the general principle there, BEE only applies to your South African businesses. So if you have a company that operates all over the world, for BEE compliance and measurement purposes, you would only look to your South African operations. I mentioned sale of equity in foreign ops, because there is a potential benefit more in the context section 102, and we can talk about that in a little while. Right. I mentioned before the different categories. So what we have, it's the same as the generic codes. You have the 3 categories of entities. You have your exempt micro enterprises, and those are entities that are 10 million and less. Then you have your qualifying small enterprises, and those are the entities between 10 and 50 million. And then large enterprises, and those are entities over 50 million. Now, there's also deemed recognition levels. These are the same as in the generic codes. So any exempt micro enterprise automatically gets a level 4, which allows you to get 100% BEE procurement recognition. And then also, if you are 51% Black owned, you get an automatic level 2, and those are only applicable to EMEs and QSEs. And if you are 100% Black owned, EMEs and QSEs, you get a level 1 dispensation, which entitles you to 135% procurement recognition. Procurement recognition is essentially how much of the spend you can claim. So obviously 135% means that you can claim more than what you actually spent on the particular procurement. So if you spent 100 Rand on procurement, you can claim 135 Rand in the case of a level 1 entity. Level 4 entities can claim the full spend. Obviously, if you're level 3 and 2 and 1, you can actually do much better. Okay. Right. Priority elements is something that was introduced when they amended the Act. Now, these elements, what effectively the rule is that is if you have to comply with these 3 priority elements, if you don't comply with, well, it's a sub-minimum requirement that you have to comply with. If you don't comply with the sub-minimum requirement, you can be discounted on your scorecard. So, for example, if you were level 1, but you haven't complied with the minimum requirements, for example, the ownership element, then you can be discounted to 1 level. So the elements that are applicable here are your ownership, your skills development, and your employer and your enterprise and supplier development elements. Ownership, the general principle around all of these is the sub-minimum is that it's really 40% of the points available. In the context of ownership, it's only 40% of the net value points. So net value is one of the measurement categories on the ownership scorecard. Essentially what it does is it measures the net value to a black equity participant minus any debt, so that you can actually then attribute an economic interest score, and then that's used for your net value calculation. There are 8 points on the net value score, so 40% of that would be 3 points, I think. I mentioned land claim farms because we'll mention it again later. In the agri sector code, there's a specific exemption for the ownership to comply with the ownership requirement if your farm is subject to a land claim. It's not quite clear if that means that the priority element also won't apply. I would guess so, because you can't comply with the ownership element in the context of a farm where there's a land claim on that farm. However, if there's separate operations, your farming ownership is separate from your ownership of the land, then you can still obviously comply in respect of your farming operations. Statement 102 is quite a novel, and I see it used a lot more to garner ownership points. Essentially, a statement 102 transaction is, instead of giving up equity in the entity, what you could do is you could sell off a business or some assets or a parcel of land in the case of farming to black people or to an entity owned by black people, and the value of that transaction would effectively be used to relate or to work out how much ownership points you could claim. It's one of the deemed ownership principles. It's emphasized in the agri sector code as a mechanism, and we'll talk a little bit about that and the additional requirements under the agri sector code for statement 102 transactions. But it's quite a useful way for those entities or measured entities who say to themselves, they're not really sure how they're going to dilute ownership. This is one way you can achieve ownership points without actually giving away any equity, by actually selling businesses and opportunities, creating those opportunities for black people. Skills development. It's largely similar to what we have in the generic codes. The priority element, because it's a priority element, your sub-minimum target there is 40% of all of the points. Different to ownership, where it's only the net value points where you have to get the minimum. Yeah, you have to get 40% of all the points. We'll talk a little bit later specific more about skills development. Just worth noting here that the target is for skills development is 6% of payroll, which is quite a lot. And if you look at the generic codes, the starting point is 3.5%. But the generic codes also then provide that you have to spend another 2.5% of payroll on bursaries, for example, for black people. So that would in any event equate to 6%. And here they don't have the similar bursary requirement. They just have a generic skills development requirement, which is cumulative 6%. So in that sense, it's very similar and the same. You'll see it's a bit lower for QSEs. You only have 3%. of payroll. For larger organizations, it obviously is quite a significant spend, but there's a lot of things you can do, and often larger entities are in even subject to Skills Development Act and levies, etc. And a lot of the initiatives done under that legislation even qualify for BEE points. Okay, then we have enterprise and supplier development as the last one. This is the single biggest element on the codes, and in fact, probably in most of the codes, we'll talk quite a bit about it, and it's the one that essentially the glue that keeps BEE together, because this is the way that we regulate the engagement between BEE entities in the market. The requirement for not being discounted there is you have to achieve 40% for each of the 3 subcomponents of enterprise and supplier development. Those are preferential procurement, enterprise development, and supplier development. What's interesting about, we'll talk a little bit about later as well, what's interesting about the agri-sector code is that in the case of 51% black-owned QSEs, you have some phased-in requirements here if you meet certain targets, which is quite different to what you have on the BEE codes, and it's specifically applicable to QSEs, and because I think they want to encourage. It's specific applicable to large enterprises, but we'll talk about it later. How they're actually looking to fostering a better economic development quotient. Let's just go through the elements now and discuss them in a little bit of detail. So as I said to you, you've got your ownership element. It's broken up again into your large and your QSE. It's the same as the generic codes in substance. There's no real difference. What is interesting is that it's mentioned in the agri sector code that this target, the 25%. So essentially, the target is you have to achieve maximum points. You need a 25% black shareholding and 25 plus 1% vote. That's the same as the generic codes. What is interesting is that that's going to be reviewed every 2 years, and they've specifically mentioned that the target for ownership was kept low in this sector code because of the ESD requirements, and they want to see how well enterprise and supplier development is going to work, because a lot more emphasis was placed on that. The principle being that they look to larger entities to sort of grow your black industrial base, and also, promote an opportunity for black businesses to thrive. If that's done, there will be a lot less emphasis on ownership, which is probably the right way to look at it. Then management control. Again, very, very similar, not much difference between that and the generic codes. What this measures is essentially the extent that you have your black management in various levels of the organization. Skills development, also quite similar to what we have in the generic codes. Again, measuring the extent to which you comply with skills development initiatives under the Act. I just want to check something. Right. Now, okay. Enterprise and supplier development. As I said before, it's the largest single element on the scorecard, quite a significant, quite an important one. You'll see the big difference between large enterprises and QSE entities, because a lot of the emphasis is 40 points available on the large scorecard, on the large enterprises scorecard, and only 25 points on QSE. So more relaxed requirements for QSEs. EMEs don't have that requirement. By the way, just so that everybody's aware, QSEs and EMEs and QSEs, certainly EMEs can get away with just doing affidavits. If you're 51% EME or QSE, black-owned QSE or EME, you can just do an affidavit. You don't have to undergo a full BBEE verification audit or certificate. So this preferential procurement is one of the first aspects of enterprise and supplier development. So there, what we have is, it's quite an interesting provision. It says that if you comply with the target for supplier development, which is stated as 2%. It's not drafted very well, but I think what they intend is they're saying that if you do 3% of your impact towards supplier development, then you can actually have a phased-in approach to the targets for preferential procurement. So, for example, the target for preferential procurement is 9 points available, and the target for buying from 51% Black-owned suppliers is 40% of your TMPS. TMPS is your total measured procurement spend. Complicated concept, but essentially, it's talking about your procurement spend, excluding salaries, etc. It's basically everything you spend on goods and services, including rental and intergroup procurement. There's some interesting aspects about imports, but essentially it's quite a heavy requirement to have 40% of your total procurement acquired from 51% Black-owned entities. By the way, that's exactly what the generic codes require. This one is quite different because if you can choose, it seems, to rather spend 3% of your NPAT on the supplier development, and then you can phase in your 40% requirement. I think it's 10% in the first year, 20% for the second year, 25% in the third year, and fourth. I think you have 3 or 4 years to phase in, which is quite a nice way to introduce entities in the agri sector to take advantage of opportunities, particularly on their supplier development and enterprise development. As I mentioned, supplier development for large entities, the target is 2%. But if you do 3%, you get the benefit of lower or the phased-in approach towards buying from certain designated suppliers. In this case, being your 51% Black-owned and your 30% Black woman-owned suppliers. All right, then enterprise development. The difference, the big difference here between this and the generic codes is that it's 1.5% impact. So which is a bit more than what you get. But there's also a very interesting part of this particular agri sector code, and that is in the context of bonus points or enhanced recognition. This one has got quite a unique set of enhanced recognition principles. So you can multiply a score by 1.5 if you do things like contribute to job creation in the sector, bringing in new players, new beneficiary entities, contributing to a warehouse fund, and importantly supporting land reform projects and land reform beneficiaries. You can actually also get additional points, which is not available in any other sector code or scorecard. And like I said before, I think there are a lot of companies in this country that are looking to do those things anyway, and now you can potentially get BE benefits from doing that. Okay, so last one is it the last? Maybe. Socioeconomic development is the last one. It's again very similar to the BE codes, except they've added a lot more potential scoring opportunities here. The category is quite wide. It actually even includes things like bursaries and skills development, etc., which would normally be skills development, but in this is actually mentioned bursaries for farm workers, etc. Also, an interesting feature of this particular sector code, which you don't get in any other sector code, is that if you provide opportunities to Black people to lease land, and in this particular instance, if 10% of your land is made available by a lease or some other contractual arrangement to farm workers, you can score all the points for socioeconomic development. Obviously, it's on a pro rata basis. Okay, I know that was a lot to absorb, but any questions are welcome. I see they're all of you. Is government SO CISO is asking, is government SO also got as being neutrally listed entities as well? Okay, so yes, from an ownership perspective. So when you look, as I said, the state cannot own anything. So SOEs that are wholly owned by the state, which most, if not, well, there are a few examples of weird ownership, but most of them are wholly owned. So you would apply what's called the exclusion principle to the ownership of the state in any entity. So that would hopefully answer that. Would you not regard the fishing sector fall outside of the agri codes? Yes, that is right. Fishing is well, it's actually primary production if you look at it quite simply. But I don't think this code is at all intended to apply to the fishing sector. As I said, it's got its own regime, it's got its own particular fishing rights allocation process, which it's been doing for many years. It does apply BEE, but it's largely in the context of generic BEE compliance, and it's not really worked BEE as the agri sector formally has done it. It hasn't done that. It hasn't worked it into its entire value stream for the industry. So Andries, is a question for you. The rights B scoring, I would guess it's still the case. I didn't know that you needed for B for water rights, but it makes absolute sense that they would do that. So yes, you would definitely have to, but now the difference would be, as opposed to previously where you may have had to apply either rules made up by government departments or the generic codes, which are, like I said, of generic application. Now you have specifically going to have to apply the agri sector code. Okay, the presentation will be shared. So interesting point about the 10% farmland. Must the farmland be owned? Can points be obtained through subleasing? I suppose it depends on your structure. I don't think automatically subleasing. Doesn't sound like you would necessarily be, but it is possible. It's not something I've really had to look at, before. The principle being that you must make land available. I suppose if you are the operations, if you are running a farm and you're leasing the farm and the landowner itself is not really, scoring or looking to obtain any B points, and you're the trading entity, you own the farm, you run the farm, then I think you probably could, because in a sense that's a sublease, although it's really in essence a primary lease if the farm owner or the landowner gives you those rights. Interesting question. I think you can structure it that way. Yeah. Okay, so discussion of the revised threshold for EMs and QSE. So the codes do provide that these should be regularly reviewed. In fact, in this particular code, there are sort of 2-year, as a rule, principles about revising these thresholds. They haven't been revised. I'm not sure they're going to be revised anytime soon. Bear in mind, I mean, as Andries pointed out to you, if you look at other legislation in the country, particularly in the SMME space and the regulatory environment, the thresholds are a little bit lower. 10 million exemption, 10 million turnover exemption is quite high in the current economic climate. Yes, of course, we'd all like it to be higher, to get more exemption, but I think that the principle is rather to include more than to exclude. So I don't see it changing immediately, but yes, it can. I mean, the government can change those, and those can all be updated. I think that's it. Okay, I think that ends my presentation. Thank you.
Yes, thank you very much for your attendance today at this webinar. We really trust that you found it informative and of value to your business. I also want to thank the 2 speakers for the job well done, and also great that they stick to the time limit, which is sometimes quite difficult. For more information on our sector, the agriculture, aquaculture and fishing sector, please refer to the brochure that will be sent to you later today. The brochure will be sent together with the slides of this webinar. We thank you, and we trust that you will have a pleasant day further.